Welcome and thank you for joining part 1 of Seyfarth's micro webinar series, Legal Insights for the Transportation and Logistics Industries. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to two of our labor and employment attorneys, Sewell Kim and Tom Posey. Sewell, you may begin.
Great, thank you so much, Brooke. Hi, everyone. My name is Sewell Kim, and I'm a labor partner located in our Atlanta office. And I'm here with Tom Posey, another labor partner located in our DC office. Next slide, please. So Tom and I will cover the following topics on today's webinar. I will cover the first topic, where I will discuss the strike activity in 2023 and discuss its impact on bargaining in 2024 and beyond. Next slide. So 2023 was a banner year for strike activity. There was a wave of high-profile strikes that were widely publicized to the point that the public at large knew about it. For example, the Starbucks walkouts, the Teamsters threat against UPS, Teamsters threat of strike at UPS, the UAW's spot strikes against the big three, and also the healthcare workers strikes. And in 2023, not only were there a number of high-profile strikes, but there was also a record-breaking number of strikes at 345 strikes total, which is the highest yearly total in more than 2 decades. In fact, the strike activity in 2023 is described by some as a resurgence of strikes and rather than a rebound of strikes for the following reasons. First is that if you look at the data in 2021, the strike activity has already surpassed all pre-pandemic years going back to 2007. And since 2021, the annual strike totals have increased every single year. And in 2023, that was the first time since at least 1990 that annual strike totals increased for a 3rd consecutive year. So looking at the period from 2021 to 2023, some look at that and point to that as a resurgence of strike and also a growth of union picketing activity. Next slide. The 345 strikes that were called in 2023 is also impressive in its total number of workers idled by union strikes at 530,287. This is far more than the number of workers idled in all the previous 3 years put together, which is 2020 to 2022 at 396,346. And when I compare the total number of workers idled by union strikes in 2023, which is 530,000 or so employees, against the numbers in 2020 to 2022 separately, it's more impressive. So in the 530,000 employees idled by union strike in 2023 is twice as many more workers idled in 2022, 4 times as many workers idled in 2021, and 10 times more workers idled in 2020. Next slide. So now let's look at the average number of workers idled per strike in 2023, covering about 1,500 workers per strike. This is the 3rd highest total since 1990, as you can see in the chart. This is also more than twice the overall average of 760 workers per strike over the last 33 years. Next slide. And while 2023 had a lot of big strikes and a lot of high-profile strikes that covered a lot of workers, the duration of strikes is that they didn't drag on. In 2023, the strikes lasted shorter and resolved sooner. As you can see on the chart, all the way to the right, in 2023, more than half of the strikes that started in 2023 were resolved within 7 days, and more than 2/3 of strikes that started in 2023 were resolved within 14 days. Next slide. So now let's look at the strikes by union, the top 10 unions by strikes called. The SEIU tops the chart, and that should not be a surprise to anyone because the Service Workers Union was responsible for almost all Starbucks walkouts in 2022 and 2023. And when you look at the Teamsters, who is most familiar to this group, Teamsters took the second place with a total of 43 strikes called in 2023, involving 12,377 workers. However, when I look at the data for top 10 unions by strikes called in 2000 to 2023, which is for over the 23-year time frame, the Teamsters actually takes the top place. The first place with a total of strikes called in 982. And when I look at this list and think about all the strike activity that occurred in 2023, it makes me think that in 2023 and maybe in 2022, that going out on strike almost became its own objective rather than a bargaining tool. I think a lot of unions did use strike as a tool to flex their muscle and show its members and other unions their strength. Next slide. So now let's dig little deeper into strike patterns in 2023. And what you are looking at is a chart for monthly strike totals in 2020 to 2023. And the bright green line depicts the 2023 numbers. In 2023, the busiest picketing months were May and September, which follows the norm because the strike activity, is high during warmer months. But in 2023, what was a little bit different than the norm was that the strike activity was unusually strong from October to December of 2023. And this defies the norm because, during the winter months, the strike activity typically tapers off. But in 2023, the strike total only decreased by 5 from October to December. Next slide. The most important and interesting development in post-pandemic strike activity is that the unions were not only calling strikes during the renewal of the CBA, which is depicted by this green color, but also during the first contract negotiation, which is depicted by the purple color. The chart that you're looking at shows that there was a huge increase from 2020 to 2023, where you see a surge of before first contract strikes. And in fact, in 2022 and 2023, you'll see that there were over 100 strikes over first contracts. And additionally, the term before first contract includes the strikes called by union on behalf of workers who are not even their members. So the recognition strikes. So about 1 in 5 pre-first contracts were strikes for union recognition, which also coincides with the surge of union organizing during 2022 and 2023. And, some may look at this chart and say, this is skewed because, all the first contract strikes were called against Starbucks. But when you look at the data, there were a lot of union recognition strike against Starbucks, but they did not even amount to or account for 1/3 of organizing related strikes. Next slide. So following the resurgence of strikes in 2023, what does the contract look like? And today we'll look at just the wage increases in union contracts that were ratified in the first quarter of 2024. What's interesting about this data is twofold. One is that based on the wage increases negotiated in the 155 contracts ratified in the first quarter 2024, averaged 7.3% without lump sum payments and 8% with lump sum payments. And this is the highest average increase negotiated by unions since at least 2008. But the second point is more interesting. So when you pull back, zoom out a little bit and look at the entirety of this data, which goes from 2010 to 24, you'll notice the average first wage increase from 2010 to 2020 is pretty gradual and pretty modest at 2 to 3%. But at beginning in 2021, there's a huge uptick in average first wage increase. And this was even before the strike activity of 2022 and 2023. And what happened in 2021? We were still recovering from the pandemic. We were still facing the widespread labor shortage, supply chain issues, etc. So I think this data at least supports that the strike activity was not the sole cause of the average wage, first year wage increase, but it could at least contributed to the external stress factors that were not within control by the unions. Next slide. Okay, so and this one is just a snapshot of the first year average by US Census region. And you'll notice that the highest average first year wage increase was in the mountain region at 10.7%. Next slide, please. So at this point, after looking at the analysis of the strike activity in 2023, I think the first question you have in mind is, okay, so did the increase in strike activity have a tangible impact on contract outcomes? And what I hear from my colleagues and clients is not really. It's hard to pull apart the perfect storm of a global pandemic, precipitous recession, supply chain crisis, labor shortage, labor-friendly administration, and proliferation of union organizing, and also union militancy, and really truly identify the true reason behind the record contract settlements. But we also haven't heard from clients that say the contracts that settled at a range beyond its expectation, despite the strike activity. But I think it is true that unions' willingness to prepare for, threaten strikes well in advance, and also engage in creative strikes like the UAW's spot strikes helped in achieving a record-breaking contract settlement. And also large unions like Teamsters announcing well in advance to companies that they have a fat strike fund that they can draw from while the employees are out in a prolonged strike. That definitely helped bolster the Teamsters' threat of strike, and also encourage companies to engage in bargaining before employees went out on strike. But to say that the union strike activity was the reason behind the impressive contract outcomes, I think that's a little bit of a stretch. I think that we can say that there was a coincidental impact that the strike activity had on contract outcomes, but not a tangible impact, and it wasn't the sole cause of it. What I like to say is that I think, in short, the strike activity was in the right place at the right time in the perfect storm, and it definitely contributed to the impressive contract outcomes. So then second question that we get a lot is, okay, does this mean that demands will only go up from here? And the answer is, we don't know, and no one knows. Some may say that employees who were organized in 2023 and are bargaining in 2024 witnessed the union's display of power, and they're going to expect and demand and drive higher demands. But also some will say that the demands are expected to be leveling off a bit. There is a cost to new contracts with higher payouts, and with the slowdown of business, recession in the near term, and many large businesses announcing layoffs, even those companies whom Teamsters and the UAW have won large contracts, I think the unions may not be as bold as they once were with their demands in 2023. So then a bonus question. With the election around the corner, how will the election result change the National Labor Relations Board? It depends. Lawyers favor saying it depends. As many lawyers who practice in this area knows that if there is a change in the administration, there's also a change to the board. And the NLRB members serve a 5-year staggered term, and one member's term expires each year. And this year, Chair McFerrin's term is supposed to expire in December of 2024. But recently, President Biden renominated Chair McFerrin and also nominated a Seyfarth colleague, Josh Deidelberg, for the vacant Republican seat. So since the Democrat Senate is likely to act on both of nominations at the same time, if Chair McFerrin gets confirmed before the election, then the Democrat NLRB majority will hold its place until August of 2026. Which means that the Democrat majority NLRB will continue to pursue their pro-union, pro-employee agenda, and that they will do what they can to protect all pro-union decisions that they've made so far. But if the Senate does not move on the confirmation and the Republican nominee, Donald Trump, wins the election in November, then you're likely to see a Republican NLRB majority in place in 2025. And then they'll do their best job to undo many pro-union precedents and replace them with pro-company decisions. And additionally, if Trump gets reelected, then he may follow President Biden's footsteps and terminate the current GC, Abruzzo, immediately after taking position, and then install a business-friendly GC to replace her, which means that the board is now going to be more business-friendly if that all happens. But again, it depends on the Senate, it depends on the election, so we'll see. And with that, I'll turn it over to Tom.
Thanks, Sol. And Brooke, could you hand me back control of the slides, please? I think we exchanged that. We were going back and forth here. And so while we're waiting for that, hi, everybody. I'm Tom Posey. You may have been a little confused on that first slide. I am actually not in the DC office. I split between Chicago and LA still. So still those two cities. No room for a third one, but we'll just stick with those two for now. So the second piece we're going to talk about here is some developments over just the course of the last few months. Now, there's a number of things that I think we all, frankly, thought were pretty well established, things that were not going to change, but some of those things are really getting shaken up now. I mean, one of those that a lot of you have already found out the hard way is there's a big push by the NLRB, by the General Counsel in particular, to ban captive audience meetings. Now, there's also state laws and local laws popping up to try and stop those meetings as well. Now, that's something that's been around forever that we didn't think was going to change or go away or get shaken up, but it has. And this is all over the place. I don't know if you've been watching other news, not just in labor. The creator of Hello Kitty just recently told us all that the character is not a cat. Now, I don't frankly know how to deal with that one. I wasn't sure how to respond, but we're having a whole separate webinar on that next week. So you can tune back in for that one to see what plans you'll need to make in response to that. Now, the third one, though, is changes to what it takes to establish a right to represent employees and whether you need an election to do that. And that, of course, is the CEMEX decision that came out earlier this year. And I would note that is pronounced CEMEX, not CMEX. There's been heated debate over that, certainly around the firm and elsewhere. This ended up costing me $20 because I was positive it was CMEX. And then finally, after all this back and forth, we just called their corporate headquarters and they said, hello, CEMEX. So I lost $20 and now we know how to pronounce it. But in any event, what we're going to talk about is how the CEMEX decision has impacted organizing in the industry so far this year, and what are the practical implications for your operations. Now, again, I know some of you who are on this webinar right now are saying, well, I know exactly how it's going to impact us because we've dealt with this 3 times already. But I think some of the lessons that you've learned so far will be helpful for some of your friends who are here on the webinar going forward as to how to respond to this and what are some of the best practices you can take. So 3 different areas we're going to talk about. First, volume of organizing. Now, before this decision came out, there was certainly a lot of discussion about what is this going to do to organizing. I know Sewell had a lot of great statistical data that we just walked through on what's going on over the last few years. I have prepared a similarly detailed and complex analysis for you. It's gone up, okay? Now this one, we're not going to get into just for time constraints here, all of the specifics on the stats, but as expected, the volume of organizing has gone up some as a result of this decision. And it's in large part because it's easier to do now. You don't need to do as much to get to the point where you're actually representing the employees or at least getting an election to happen. So let's walk through why that is. Once that decision came out, it had a pretty immediate impact on the strategies and tactics that the unions are taking from an organizing perspective. Now, we'll walk through some of the details, but as a lot of you know already, the biggest change here is that it allows a union to, if they have enough support, and I pause there and put quotes around enough, because it's if they have enough support or if they claim to have support that does not get checked, then the next step potentially is for them to go right to bargaining, right to representing those employees. Now, a lot of you, rightfully so, have pushed back in response to those letters. We haven't just taken those at face value, but even the letters themselves are important because the kind of language that the unions are using in those letters, although as Sewell said here, it's for the most part, or the largest part, it's the Teamsters, for those of you who are on with us today. They're really using these letters to their advantage to try and in some cases sort of slide this through with the companies they're sending to. So let's look at one of these demand letters. Now, we've obviously taken out the employer's name here and just plugged in a random local number here. But this is an actual demand letter that was sent to one of our clients. Now, there's a couple important points here in this language. The first one, if you look in the second paragraph here, is that we are prepared to demonstrate the union's majority status amongst the drivers through any reasonable procedure for verifying the signed authorization cards. So part 1 here is that when the union sends one of these letters, they're claiming, all right, we've already got a majority of the drivers have authorized us to represent them, so now we can just skip ahead, no need for an election. That's essentially what this decision boils down to. So here, to the extent the union is claiming majority status, if we have any reasonable basis to question that, to oppose that, we should do so. Now, you won't always have that. In some instances, you know that there's a lot of employees are already interested, hopefully not already a majority or all of them. But if we have any good faith basis to object to this claimed majority status, this claimed number of authorization cards they have, we want to push back at that point. Now, the second piece is in the event the employer refuses to recognize the union as a representative of the drivers, we're prepared to file a petition for an election with, well, in this case, it was Region 13 of the NLRB. Now, why is this important? There's 2 reasons. One is you do have the right at this stage, after getting one of these letters, to say, no, I don't think you have majority support, and there may be other bases for you to object to their next step or to disbelieve what you're receiving, and to say, we're not going to take any action in response to this. We're not going to do anything. Now you have the right to do that, but here's the difficulty, is in this particular letter, this is one where the union affirmatively said, we're going to go file our own petition if you don't. There is some risk associated with this though, because if we don't, at this point, make some kind of response within, and we'll talk about this in more detail in a moment, but if we don't, within a couple weeks of receiving this letter, take action ourselves to file our own petition with the NLRB, then we run the risk of that union then going to the NLRB and saying, the employer didn't respond to this demand. We have a majority interest already. We're asking you to issue a bargaining order. Tell the employer, just go to the bargaining table, no election needed. So that's a big risk to take, especially when we get one of those demand letters that doesn't include this highlighted language here, because they're not required to. Sometimes you'll get the letter without that statement in it. But again, even if it's there, we can't just accept that or assume that that's the route that the union's going to take, that they will file their own petition. Now, part two here is with the letter itself, it's not just the language that's in the letter. Since there is a time window here that we need to respond within, the unions are creatively choosing who's getting these letters, where they're being sent, when they're being sent. So for example, and again, as some of you have found out the hard way on this call or this webinar, is that sometimes they're choosing someone who is technically a management representative. It's not an hourly employee, but it's someone who would never and has never before received anything like this letter, hoping that, well, this person receives it, maybe they won't know what to do with it. Maybe they'll delete it. Maybe they won't forward it on for a week or so because they think it's not important. Same with the timing of sending this out. In the most recent one of these we received for one of our employers was sent out on Friday at 11:30 at night. Now, again, that wasn't just because the union is working so hard on Friday evening. It's because the hope is this one's not even going to be noticed. Maybe not until sometime a week or so later, maybe never. Now, also the language, as we talked about, they're going to choose that language carefully. Sometimes it's going to include that statement that we're prepared to file a petition or we anticipate filing a petition, something along those lines. But again, even if that's there, oftentimes there is no plan to file a petition. That's there to potentially lull you into a false sense of security where you say, okay, well, we can just wait and see what happens. Let's see if they file one. Where it may be the case that the whole reason that language is there is so that you won't go forward and file your own petition to protect your right to actually have an election versus the union just rolling right in, taking representation, and then having to move into bargaining. Now, the next important difference here with regard to what happens after one of these letters comes out is the union essentially doing their best to draw a foul, okay? What they're going to do during this organizing period, during this initial period, is anything and everything they can to establish that some sort of unfair labor practice was committed. So they've got a basis to go file a ULP charge. When they do that, with that is almost certainly going to be a request for injunctive relief from the NLRB saying, please take affirmative steps yourself because the employer has committed some unfair labor practice that means there's no fair way to do this even if we go forward and have an election, so we shouldn't have one at all. Just come in and order the employer, get to the bargaining table. Party's over, now you've got a bargain. There's not going to be an election. So there's definitely more risk here than there used to be, both with regard to the time frames and how quickly we need to respond to these, but also what's happening on the ground in response to these requests or these demands. Again, going back to who are the targets, one thing that the unions are hoping, and in a number of cases are going to actively try to make happen, is get someone who's unfamiliar with this process to unwittingly commit an unfair labor practice. And that can go as far as targeting specific individuals, low-level supervisors or managers who are high enough to be beyond hourly employees who could be in the bargaining unit, but to go with those folks, talk to whatever employee or group of employees is sympathetic to the union, maybe who brought them in the first place or has been collecting the cards, and say, hey, who do you think is the supervisor or the manager who we'd be the most likely to be able to tick off if we were having a lot of activity? Who do you think we could get a reaction out of if we're essentially poking them in the chest? Not literally, hopefully, but if we're, trying to get a rise out of that person. Once that's been identified, then those employees or the organizers who are on site or out in the parking lot, out on the street, are going to do what they can to get a rise out of that person as they sought to. And if they can, hopefully, then for them, they're getting some basis for an unfair labor practice charge they can file, again, to try and skip a step here and say, we don't need an election at all. This unfair employer that's committing these unfair labor practices doesn't get to have an election. And by the way, we've got all right, sorry about that, everybody. That was your water break if you needed one, so let's get back to it. So Brooke, it looks like we're still not able to advance the slide. So are you able to do that on your end?
It says that you have control.
If you could click on the slide itself on the screen and then go ahead and hit the arrow keys, you should be able to advance it. There you go.
Okay. Like we've got some delayed reaction here. I got several clicks, so hopefully it won't disappear on us and go back. Okay. So let's talk about responding and effectively responding when we get these kind of demands or these letters. Now, first and foremost, as we already talked about, is this window of time that we're dealing with, okay? So the most important thing you can do there, besides obviously just don't miss the window, is you're gonna have to educate your people and make sure they're aware of this issue, that this even exists. If they're not, then we're potentially gonna miss that deadline, that couple-week window without even knowing it. Now, an employer is going to potentially violate the act by refusing to recognize, upon request, a union that has the support of a majority of the employees. So again, that's assuming that majority support is really there, unless the employer promptly files an RM petition, an election petition of its own, to test that majority status. And now here that's unless an RC petition, a union filed petition, is already out there. Now this is where that risk comes in we talked about in that demand letter, that we can't just assume, even if the union says we're going to file our own petition, we can't just assume they're going to. So during that 14-day window, we've got to make the decision, are we going to file our own petition, assuming we do not have some basis to test that majority interest? And in most cases, the answer there is going to be yes, because if we let the 14 days go by, we're running the risk that we may not end up where we wanted to be before that. Now, related to this education piece, it's not just the timing, but it's also the unfair labor practices. So if this is especially your first organizing campaign you've ever faced, or your first demand letter like this that you've received, or even if the company has lots of experience here, but this particular facility or location Or more importantly, even this particular manager or supervisor who's over one or more of the units that are at issue, if they don't have experience with this, you want to, as quickly as you can, get those folks educated and up to speed on what it takes to avoid committing an unfair labor practice during this time, and what you are and are not allowed to do. And so we don't unwittingly just hand this over to the union, either by an inexperienced group or individual supervisor or manager doing something they didn't realize they weren't supposed to do, or by even more simply just missing the window and waiting too long because they're not realizing they need to take action quickly, or there's a risk of losing our opportunity. Now, with that response strategy, another piece is your education of the employees, your outreach to the individuals who have supposedly signed those authorization cards. Even if you've been through this process a number of times, you've had your tips training, you're confident your managers and supervisors know what they should or shouldn't be doing in these situations, it's still a good idea to at least have some kind of a refresher with them, make sure everyone is up to speed, because whatever you're deciding more at a global level, maybe in the executive offices, as to here's how we want to respond to this, we're not going to challenge the cards, for example, because we don't think we've got a basis to overcome this claimed majority of authorization cards signed, but we do think we can win if this is a campaign that goes on. In that case, in the interest of trying to get as much time as we can, you may decide that on the very last day within that window after receiving the letter, that's when we're going to go and file our own petition, so that we're buying ourselves that time. We've got at least a couple weeks to take action, then file our own petition if the union hasn't in that time, and then go forward from there. But in that initial window, those first 10, 12, 13 days before you file your own petition, we're still at risk there, and we're going to be under the spotlight. Often, we're going to be under active efforts from the union to try and trip up our folks on the ground, to get somebody to commit an unfair labor practice, or even something resembling an unfair labor practice that'll give them enough basis to go file a charge and say, wait a minute, hit the brakes. Employers shouldn't get an election here at all because this unfair labor practice has happened, okay? So the two biggest takeaways here, I think the most important parts are, first, make sure everyone at the ground level, the local level, knows, is made aware of, and understands that there's this new and different requirement for this time frame, so that anybody who receives an email like this or gets a letter in regular mail understands the urgency and knows what to do with it. So that may be as simple as you just sending out an update email to your folks. It doesn't have to be that there's a 2-hour labor relations training. You can just send something out, whether it's an email, it's an alert, whatever your internal system is. Do something, and I would recommend as soon as you can, if you haven't done this already, do it tomorrow, do it next week. Get that out there so that people understand that. The second one, which is a little more involved, is making sure that all of the education for all of the people that are on the ground when you face an organizing effort are up to speed on all of their tips training. They understand what you can and can't do, that nobody's going to unknowingly step over the foul line and end up essentially giving away the game to the union without even knowing that they've done so. So I know we went quickly through a lot of different topics and material here, so we've got just a few minutes left, so why don't we open it up for questions if anyone has any. In the meantime, we've also got the CLE attendance verification code is up on the screen. That one, I will not touch the keyboard again because I know this one's important for everybody, so I don't want this one disappearing too quick. But while you're taking down that code, if anybody has questions, please put those in the chat and let us know, and we'll be happy to answer them.
Tom, I just want to add to your comment about unions making demand for recognition. while it is most common for them to make a demand for recognition via a letter or email, I think it is important to educate your employees that this demand can come verbally or in person. So if it comes in those fashion, don't ignore it. Still follow the process.
Thanks. So that is an excellent point, and that is absolutely correct. Is that, one other little cute tactic here to take is to make this request in person. Well, listen, we've already got everybody sign these cards, so we've got to go forward here. And then someone just kind of blows that off, and then later on, there's going to be something filed that says, well, on August 22nd at 12:22 p.m., I was standing in Sewell's office and told her, quote, and it's certainly going to be a different quote probably than what was really said to her, with much more detail and probably some legal language thrown in. But that's absolutely another risk there. So you've got to take any demand like that seriously. And I see one of the questions we've got is, what if the demand letter is submitted to someone who's not a Section 211 supervisor, who's not eligible to be in the bargaining unit? Can the employer challenge that as an invalid demand? The short answer there is yes, you should. Now, in general, I think the union is probably going to do some homework to try and make sure whoever they're submitting this to, especially if it's in writing, is somebody that will stick. But that said, don't just accept that. If they make a mistake, if it's not someone who is actually a 211 supervisor, then you absolutely can and should push back there. I think that's the only question we have in the chat. So if we've got a minute or two left, if anybody else has one, we'd be happy to answer if you want to put one in. And for those of you that haven't gone through this yet, if you do already have a process in place, meaning you've had elections before, you've had union campaigns before, the good news is most of what you did before, you're probably not going to have to change. So once you receive this demand letter, as long as you're understanding that, unlike in the past, I may need to go file my own petition right now within the next couple of weeks, if you don't, if other than having to do that, which you probably haven't had to do in the past, most of what you do going forward from there is going to be the same. And we've got one more question just popped up. How should employers go about educating frontline employees who are not 211 supervisors about the CEMEX process? Seems like something to be very careful about. That's true. And this comes back again to probably what some of you have dealt with before, just in general, for trainings related to union organizing, where you've got to decide how much and how often are we giving these trainings so that we don't sort of create a buzz about this on our own, where the employees are saying, wow, there's been all kinds of trainings lately about unions. There must be something going on. Maybe there's a union coming in here, and then we've lit a fire on our own accidentally. I think the short answer there is how to do this. It is something to be careful about, but it's not any more careful than you're being now, or hopefully being now. So if you are going to provide that education to those supervisors, even the lowest level supervisors just above the bargaining unit level, just make sure that when you do that, part of the messaging is to fill them in on the facts, either to say, listen, we don't have an organizing drive right now, everything's fine, we haven't gotten a demand letter, but here's what you need to know in case this happens. Or if we're already to the point where the letter has come, certainly there's more urgency and frankly less risk as far as being careful what we're talking to them about or educating them on. But hopefully by the time that demand letter comes, we've already had those conversations with them. All right, well, we're going to be respectful of everybody's time. I know we're set to end at 12:45, at least 12:45 Central. I know we're all in different time zones, but we're about a minute past that. So thanks everyone for joining us today, this morning, this afternoon, depending where you are. and we'll leave the code up here for another moment just to make sure everybody's got time to get that down. And if you have any other questions after we log off, please feel free to email Sewell or I, and we'd be happy to help.
Thank you all.